I'm going to.
Oh, I see Joanne on there.
Good afternoon, everyone. Welcome to Mindset Monday. Yet another Monday. Here we are. I sure hope that everyone enjoyed the beautiful weather yesterday. Spring is around the corner, we hope. Thank you once again. We're pleased to have the Rinaldi Silva team with us to address assignment agreements and the complexities that are contained in those agreements. And unfortunately, Paul Silva, our head speaker, his video is not working today, so you won't see his handsome face, but you will hear his voice. Go ahead, Paul, and take it away.
Thanks so much, Louise. I really appreciate the opportunity, Louise and Ivana. Can you hear me okay? Just please confirm.
We can hear you. If your volume can be a little bit louder, that would be great. Maybe a little bit closer to your mic. Thank you.
Perfect. Okay, so hopefully that's a little bit better. Good afternoon, everyone. Hope everyone's doing well and surviving our crazy real estate market, and also all of the news all of the news we're being exposed to is there's a lot of stress in the air. So certainly on behalf of the firm, our best wishes to the people of the Ukraine and all of you in dealing with your stressful stuff. So one of the challenges that you face from time to time is with respect to assignment agreements. And so we've been asked to present today on account of assignment agreements so that you can have some basic knowledge beyond perhaps what you already have, and some guidance with respect to some clauses that you can use as well. And I prepared a PowerPoint presentation. I'm speaking on behalf of the 4 lawyers in the firm. So there's myself, Vince Rinaldi, Joanne Lagutis, who's on the call, and Matt Timms, who's recently joined us and is now part of our real estate and corporate group. So without further ado, I'm going to present on assignment agreements. So just very briefly, our firm handles real estate matters, just like these assignment agreements we're going to talk about, in addition to obviously your standard real estate transactions. Our pricing is competitive. We have a really strong admin team, and we're here to help you get through the most difficult transactions. Some of the realtors in your office have been with us where we've handled things that were super stressful, but we got through it together with your professionalism and ours. So what's an assignment agreement? With the lack of inventory, some people have taken to assigning agreements that they have themselves signed. And so they may come to you and say, hey, I have an agreement for the purchase of a property. I don't want to close, or I think I can flip this for more money because I'm being told the property is worth 50 or 100,000 more than I agreed to pay 2 months ago or a month ago. Or I bought a new build and I'm told that they're worth a ton more money. I'd like to flip it. So can I assign this? So they might ask you how you're going to put all that together. That's the reason we're talking today. So an assignment is where an original buyer, who we're going to call the assignor, has entered into a formal agreement of purchase and sale to sell their contract to a new buyer who's the assignee. So assignor and assignee, those are the 2 terms we're going to use a lot today. So the assignee is not buying the property from the assignor. In truth, they're actually buying the right to acquire the property from the real seller or the original seller. So in essence, the assignee steps into the assignor's shoes. So your new buyer steps into the original buyer's shoes to complete the original contract. And there's of course going to be a contract drawn up between the 2 of them, which is separately marked up, separately prepared, where there's a markup that's payable to the assignor for the privilege of buying the contract. So basically it's buying a piece of paper, to simplify. Okay, a piece of paper that's worth something. In our market these days, with the lack of inventory, people can't find properties or overbidding, as you know, or bidding wars. So the agreement is worth a lot these days if there's one in place. So the assignment can be used both for used property or new builds. We're going to talk about both today, but they're treated differently. Okay. So it's important to understand that when you sort of look at the nuts and bolts of it, what we're talking about is legal obligations that are being assumed. So the assignee, the ultimate buyer, assumes all of the legal obligations and duties of the assignor that were in that original contract. Okay, those would be including things like the requisition date, the included items, any deposits paid, any required disclosure statements, and of course, the agreed upon completion date. So it's very important to look at what that original contract has in it. Quite apart from what seems in many cases to be a great opportunity, to buy a property. Often it's off market, and to be able to buy it on an assumption basis, you're also agreeing to the terms that were previously negotiated, whether good or bad. You can't go back and renegotiate them on your client's behalf, and your client can't renegotiate them. So I guess it's important also to explain, though, that if your client happens to be the assignor on that transaction, so the party that's selling the contract, they're still liable unless they've been released. Okay, so the fact that they've signed a contract to sell or assign their contract doesn't mean that they're alleviated from any previous obligations under the original contract. And in fact, we'll talk today about how on a new builder deal, most of the time the builder will not release the original buyer, the assignor. They'll hold both parties liable on a go-forward basis. Okay. Along the lines of they're buying what's already being negotiated, sometimes the deadlines have passed. So for example, on a resale, well, both a resale and a new build, but the title search date, the requisition date may have already passed. Who knows if the assignor completed that, or rather if their lawyer did it, if they found any issues, if now the purchaser is hampered by something they didn't do. So that's something you're assuming. Those are very important, because if the requisitions have passed, or if conditions are not satisfied, etc., again, the ultimate assignee is going to inherit those issues. So who's assigning their agreements? Well, there's lots of people that are doing this, again, probably because of inventory and because of the way the market is. You have wholesalers. So some of the wholesalers will look for people that are selling. Sometimes it's people that will post their homes for sale on Kijiji, on Marketplace, on their Facebook page, saying, I'm looking to sell my house privately. I don't want to pay a realtor. Shame on them, obviously, for not wanting a professional to help them get top dollar. But it's a free country, and sometimes people will try and sell privately. Someone will come along, smells a great deal. These are often wholesalers. They'll agree to purchase that person's property so they don't have to go to market. They don't have to pay real estate commission and all of the benefits that they'll sell to them. And then lo and behold, they're going to turn around and flip those purchase agreements to someone who's going to pay probably closer to fair market value. And there's all kinds of people doing this, as all of you know. Those flippers will basically, they'll be the ones that are putting the little pamphlets in people's mailboxes saying, I'll buy your house, cash buyers. They want to cut all the realtors out. So those are some of the people buying or assigning their agreements. Then there's also regular people that they can't close, unexpected circumstances. Maybe they have a change of heart, or amateurs. There's people that will do this kind of thing for, just regular people that don't do this for a living. And there's also realtors. Sometimes they'll see a deal that's just too good to be true, and they don't actually close, but they have buyers. So there's all kinds of scenarios. Those are just some examples. So if we just talk right now for a moment about resale assignments. So this is for used residential property. Okay. Under the common law, and at least this is, I'm not aware of any cases that have changed any of this, but as far as I understand, if a contract does not prohibit the assignment, so what I mean is the original contract doesn't prohibit an assignment and it's capable of being assigned, then it's assignable without having to get the consent of the original seller. What do I mean by that? I mean that the assignor can turn around and sell that contract to an assignee without having to go get the consent of the original seller. The seller may not like it, but in most cases, I don't think that they're going to be able to turn around and try and contest it. As long as they get paid and the contract between the assignor and the original seller is completed, they have no reason to be able to prohibit that. And the standard ORIA form doesn't specifically prohibit it, but I have seen contracts where in the normal course, realtors include certain clauses such as, no, this contract cannot be assigned without the consent of the vendor. I don't think that's probably pretty rare these days, but I imagine there are people doing that out there. So you got to look at the contract, obviously. Builder agreements, however, are not usually assignable without the builder's consent. And there's a whole host of reasons why that would have to be obtained. Okay, we're going to talk a little bit more about that later. So there's a real distinction between resale assignments and new build assignments. So there is a form of assignment agreement, which is your form 150, which I'll show you in a moment. I'm sure most of you or all of you have seen it. That's one form. That's the standardized form that goes along with the rest of the ORIA documents. There's a customized lawyer drafted assignment agreement, which is what you typically see in a new build. So the lawyer for the builder would create an assignment agreement specific to that transaction. And then the normal ORIA form of agreement with a detailed Schedule A explaining the true nature of the transaction. The assignee should get a copy of the underlying agreement of purchase and sale, and it should be attached as a schedule. So I'm sure all of you have had training on how to prepare those things, but the part that's a bit tricky is how to fill it out. The actual assignment agreement, and sometimes people get confused. Okay, so here's an example of the assignment agreement for a property. The total purchase price. So you can actually, I mean, if you read it carefully, you can see it's somewhat self-explanatory, but there's a couple of nuances. So first thing is you're going to put the total purchase price, including the original agreement of purchase and sale and the assignment agreement. So you're adding them up. Then you got the purchase price of the original agreement as per Schedule C. In this case was $125,000. Then you have the deposit that's paid by the assignor to the seller under the original agreement, which in this contract happened to have been $10,000. And then you have on line 4, and actually number 3, sorry to back up. Number 3 does allow for where you would put the time that deposit is paid. Okay. So then you have the payment by assignee to assignor for the assignment agreement. In this case, the markup is essentially $40,000, straightforward, right? 125 being upped to 165. That's the $40,000 spread. Here's the deposit that's being paid for this assignment agreement, which is $1,000. Okay. So in this example, what remains to be paid is going to be $39,000. Okay. So that's the way you would put this together. Sometimes there's confusion as to how much is being paid on the end. But that's an example of how you put it together. I don't know if everybody's had any experience with putting these together, but that's usually where most people run into some stress, if you will. Now, if we turn for a moment to assignments from builders, pre-construction houses or condos, like I said already, the builder's written consent is required before the assignment can take place. In most cases, builders will charge a fee. So the builders are smart. They want a piece of the pie. They know this kind of thing happens. They know there's a lot of buyers that will invest in pre-construction or pre-con, as people call it. So they'll say, sure, we'll let you assign it, but we want some of that, maybe $5,000. Not long ago, I saw one up in Waterdown. They wanted a $50,000 share of the pie because they knew there was a huge markup, right? So if they'll allow it, they're going to charge some fee for the most part. And of course, they're also going to draft the assignment agreement, as I mentioned. They'll have their lawyer draft it. So, and it's also important to know whether the buyer is moving into the property. So if the assignor or buyer was intending to move into the property or purchasing as an investment, that's going to have an impact on the HST issue. So it's advisable to get the agreement reviewed by a real estate lawyer, as the assignee is going to assume whatever the assignor had already negotiated, as I said before. But it is important to know what the buyer who's selling their agreement had told the builder as far as whether they were moving in or using it as an investment property, because that would impact the HST. Ultimately, if your purchaser is moving in and the builder is, sorry, if your assignee is moving in and the builder has consented, then that issue will likely be dealt with at the time of the assignment. But it is relevant, okay? And I give an example there. Did they negotiate any caps on development charges or utility hookups? I have seen new build contracts where the purchaser shows up at the sales office. They buy 1 or 2 units. They do no negotiation whatsoever. They've left themselves wide open to uncapped development charges or utility hookups, full well knowing they're going to just flip it. And so any, you know, the ultimate buyer, the assignee, comes along and they're buying whatever negotiation, whatever was previously negotiated, sometimes good, sometimes bad. Like, for example, I'll give you an example. We did a lot of closings at the Paradigm buildings, which are here on Fairview in close to your Burlington office. And we did a ton of those closings, and some of the people were able to negotiate caps and others weren't. So the ones that were able to negotiate caps may have had 2,000 or 3,000 in development charges, and the ones that didn't had 6,000, 7,000, 8,000. Significant difference. The same opportunity was available to every purchaser. Some chose to avail themselves of negotiating a better deal and others didn't. So ultimately, if you're acting for an assignee in this kind of circumstance, they're buying whatever's already in there. So your assignee should be looking over how good of a deal the purchaser had entered into. Of course, we can help with that. So what are the most important features of the assignment process? Well, as I mentioned, a buyer takes over the assignment agreement and pays the adjustments to the builder at the time of closing. The new and the original buyer may split the adjustments if that's decided as per the agreement. The assignment fees are typically paid by the original buyer to the builder on a new build assignment. So there's going to be fees that should be accounted for in the negotiation of the purchase price, I guess, from the point of view of the assignee. In the original contract, the buyer will have paid deposits to the builder. Once the contract gets assigned to the new buyer, they'll also take over the assignments. In many cases, the builder will ask for a further deposit from the assignee as well. In most cases, the original buyer gets their deposits back once the builder gives their signed consent to the assignment of the property to the new buyer. So if the deposits are replaced, then then the assignor will get their money back. If not, it'll be credited as part of the assignment process on the final closing. Not simple stuff, hey guys? Pretty complicated, actually. So most new home and condo purchase agreements, as I mentioned, do not allow the original buyer to assign the contract to someone else and say that any attempt by the buyer to do so, so if they try and do it without the consent, okay, if they try and list the home for sale on the MLS or otherwise, or list the property for rent, it could put the original purchase or buyer in breach of the agreement. And that's very important because most new builds say that unless there's an assignment built into the contract. And the builder could give notice to that original purchaser or assignor to terminate the original agreement, keep the deposit, and seek additional damages. So nobody wants to see that happen. So there really has to be consent requested and obtained before that party can go and negotiate the assignment of their agreement. So anyone who has agreed to purchase a home from a builder should give careful consideration to and should seek legal advice prior to signing the agreement, or in the case of a condo, during the 10-day cooling off period, in order to determine whether it's possible to assign agreement in the first place. I try and typically negotiate the right to assign when I'm doing purchase reviews for new home buyers. I try and put a clause in my standard negotiation, something at least to say that they have the right to assign to a family member without charge or to a corporation. Most builders won't agree to anything more than that without a fee being associated with it, or they'll just outright say no because they don't want any competitors trying to sell while they're still selling units. So documenting the transaction, assuming that the assignment of an offer is permitted by the builder. Again, we're still talking about a new build, that it must be documented to reflect and protect the legal rights of the parties. A properly documented transaction will make reference to the agreement of purchase and sale between the original buyer and the builder, but will also add a separate document called the assignment agreement of purchase and sale, which again, the builder's lawyer will prepare, okay? And they will not typically let out the original assignor, as I mentioned earlier. Both parties will remain liable to complete that transaction. It's pretty rare that they would let them out because, of course, if the assignee can't complete it, they're going to look to whoever is left to be liable for any damages. Now, there are some questions about HST and the new housing rebate. Okay, so the assignee's price will inevitably be higher than the purchase price agreed to originally by the assignor. So there's an interesting issue or an important issue as to whether the difference should be subject to HST, and if so, who will pay it? In most cases, HST should be listed as included in the purchase price. And if there's a rebate applicable because it's for personal use, then that will be already rolled into the price. If it's a residential, or pardon me, if it's an investment property, then it would not be applicable. And then there's also the question of maybe the original buyer may have been entitled to the HST rebate based on meeting the qualification requirements, but it's the new buyer circumstances that will actually determine whether the rebate still exists. So they would have to meet the same legislation requirements, or they can just simply pay the full HST with no rebate applied and then apply back to CRA afterwards. So often there would be a conversation that would have to happen with an accountant as well for tax advice. But ultimately, if the end purchaser, the person who actually closes, the assignee, if they are moving into the property themselves, not renting it, then they should be able to avail themselves of the HST rebate, which will be applied on the statement of adjustments. And if they're buying it as an investment, then they won't. They would have to pay it and then apply to CRA afterwards as an investor for a reimbursement.
Hey, Paul, can I jump in here?
Yeah.
Hi, everyone. Vince Rinaldi here, Paul's partner. This is quite an important point that you don't want to gloss over, because this could be a $24,000 question, up to $24,000 question. And I've, over the years seen many builders just not permit. They don't care whether the new buyer is personal or an investment. They want they're going to claim it based on the original investor's HST. So your client will need to come up with an extra $24,000 in many cases, and then apply directly to the CRA to get it back as a personal principal residence. So this is something you need to bear in mind, that it's not automatic that the builder will just agree based on their claim that they are purchasing it for their personal residence.
Yeah, you're absolutely right. And it is a $24,000 issue, which is significant for people when they're paying top dollar, and then they have to come up with that amount to close the deal, which is often not included in their mortgage. So it is a very important issue to deal with on the front end. Thank you for that. So I have some helpful clauses that we're including here, which can be sent to you separately. I don't know if Louise, you'll be sending this presentation, but the clauses are there. These are clauses that could be used if applicable in your circumstances. So these would be for basically the assignee purchasing all of the rights under the original agreement of purchase and sale. And you put the dates in together with all the rights and the deposits that were paid. The second one talks about the assignee agrees to pay all the adjustments on closing pursuant to the original agreement. And then lastly, you would make potentially the agreement conditional on the assignor delivering the original agreement together with any amendments within 3 business days. And then they would have the right to have that reviewed for their, to their satisfaction. So that would be a condition for the purposes of what I mentioned, which is really whoever's the assignee in the end should know what the contract is that's being entered into by the assignor. I got to say, in the last 3 years, I've seen some real doozies that have come through our office. I've seen agreements that were put together, not by realtors, but sometimes the wholesalers. Some are more sophisticated than others. Some are really sophisticated and do a really good job, and others are the equivalent of your curbsiders who really don't know what they're doing, and they grab an internet-derived contract, and your assignee has no idea what a normal contract should look like, but they're buying it. So you got to be wary of all those things. As well, there's a couple of extra clauses you can use if applicable. At the time of closing, the assignee covenants and agrees to perform all the obligations of the assignor and complete the purchase of the property as contemplated in the original contract, as if it was the original buyer thereunder, and indemnifies and save harmless, except as otherwise set forth herein, the assignor from any damages, losses, claims that may suffer as a result of their breach of contract. Right? So that's for the benefit of the assignor, of course, right? Because that indemnity would be in favor of the assignor if the ultimate assignee never completed. And then lastly, on the closing date, the assignee shall pay the balance of the purchase price hereunder to the assignor plus all deposits paid by the original seller, less the purchase price under the original contract and less any deposits that had been paid. So some of these may be useful to you. They're examples. Obviously, every clause can be manipulated, customized, however you feel comfortable. And I'm sure that there are other ORIA clauses you may have access to in your own system. So these are just some examples. So best practices and takeaways. We've talked about a whole bunch of stuff. This is complicated. It's only applicable if you're ever in the context of an assignment. But always make assignment agreements. In my view, it's best to have them subject to a lawyer review, just to make sure that, the details are considered. It's very exciting, you find a property that's available for your client. Your client's all excited because they're agreeing, even though there's a markup, they're agreeing to pay it. But it's the details that matter, and they're assuming those details that are already negotiated. This is even more the case with new build condos. There's so much paperwork involved. When we review new home purchase contracts, especially condos, by the time you look at the whole range of documents, you could have 300-400 documents. You're not going to read all that. Your client's, more importantly, not going to read all that. So it's ideal for a lawyer to review those things. Also, the assignor should remain liable if the assignee does not complete the closing. Anyone assigning should be getting legal advice too, obviously. Both the assigner and the assignee should get property tax advice because there could be tax implications. And the assignee is buying previously negotiated paper or contracts and no ability to change the terms unless a new agreement is signed. Novation. Okay, so these are some basic takeaways from our presentation today. We're here to help. We can certainly act on a consultation basis if necessary and help guide the fine realtors in your office as needed. And so there's our contact information. I don't actually have Matt's up there, I just realized, and I still have reference to Laura, who's no longer with the firm. She's moved on to other opportunities. So I will update that at one point. but at least you have the basic information there for 3 of the 4 lawyers in the firm, and certainly the phone number and fax number for the office. Any questions?
We do have a few questions. Thank you, Vince, for answering a couple of them already.
I do have a couple more hits. Sorry.
Please
Sure.
do.
Can I just jump in there? Sorry about that.
Of course.
Just a couple of best practices things. One of them is when you're acting for the assignee and you're buying the property, and this new purchase price is obviously a lot more. Sometimes the clients can't afford it right up front. They don't have the cash on hand, so you want to draft the clause about the additional deposit to be due upon the final closing. So in other words, when they have their financing available, because on new build condos, for example, there's the interim closing and then there's the final closing. So if you're acting for the purchaser, the buyer, the assignee, you want to make sure that if you have to come up with an extra 100,000 and they don't have it, right? You want it to be done on the financing. And the other thing is, if you're moving from say the assignor is a personal person and the new person is an investor, then you may want to negotiate a novation with the builder, an entirely new contract in the name of the investor. Because if the CRA, you can't just claim. I've had personal experience with some of my clients. The CRA will reject their claims for the HST rebate if the contract itself is not written in the investor's name. They don't care about the actual assignment. So it's imperative that they try and get an ovation, a brand new contract signed in the name of the investor. So that's something that you should be aware of. Otherwise, they may risk, not having the HST rebate when it's a rental. And I know there was a question here. I might as well jump in and answer it about the rental. So as long as you're an investor and you have a tenant with a 1-year lease at minimum, a written lease, you can apply for the residential new build landlord rebate, and you'll get most of that, I believe, $24,000 back. So that's basically the stipulation. You need a written lease, at least 1-year term, and then there's just a simple form to fill out, or your accountant can fill out to obtain your HST rebate. And the other question was 24,000. I believe that's the current max. It's not the actual HST. That's just the rebate that you were entitled to. The HST is usually much higher in total. Everybody pays HST, but people who personally occupied get the rebate, which gets assigned to the builder. So the client never sees it because the purchase price assumes the rebate.
That's right. Exactly.
Thank you, Vince.
Sorry, I wanted to add one more point about things that assignors should keep in mind. It's the capital gains exposure when they're assigning the APS, especially if it was never meant to be their principal residence. They will be hit with some capital gains tax on that.
Again, the key takeaway, get legal and accounting advice with regards to being an assignor. The difference in what the original buyer or the assignor paid versus what they are assigning for, that also, it would be the assignor responsible for any difference in terms of taxes, correct? Just to clarify.
Yeah, they're going to have to report that in their, they're going to report that as essentially a sale of a property. So they're going to want to get their advice from their accountants as to how they report it and how much and what credits they may have. But yes, it's something they would deal directly with their accountant on when they're doing their taxes the following year. They do have to account for it, for sure. To Joanne's point.
And there's an interesting question in the chat box, because we are seeing probably more assignments in the past 10 months than we've seen in many, many years, just because of the pricing spikes. Now, are you seeing any financing issues at all with your clients that are in the middle of an assignment because of the difference in the value or the purchase price second time around?
I personally haven't seen that. I think I don't know how people are getting financing on things.
Period.
Something that's it's kind of making me a little leery at this point, because I'm wondering how some people are getting the financing they're getting, but I haven't run into that issue. I don't know if Vince or Joanne, you've seen any clients with that or not, but.
Have not yet, so fortunately.
I'm assuming
that's-
it's because they're putting big enough deposits right now. It hasn't become an issue, but if you're a first-time home buyer, different story.
What we're seeing a lot of is parents going on title with their kids. That's happening more and more. It seems like most of the first-time buyers we're dealing with now, it's really the first-time buyer and one or two of the parents of one of them. if there's a couple buying, the parents will generally go on, or if it's just one person, their parents go on. In those cases, we usually put them on as to a 1% interest to minimize their exposure on capital gains down the road. But yeah, that's happening more frequently.
And in those situations, please do a co-ownership agreement, a trust agreement, because it's golden later on when it's time to sell, or if the parties separate after. It's super important to have that.
Absolutely. I think we presented on that issue some time ago, but what Joanne's referring to is, of course, the agreement that's going to say that that parent is really just a trustee for that first-time buyer or whoever it is that needs that financing assistance from the parent, and that there's some rules of engagement for down the road. If there's a disagreement or one of the parties dies, that agreement would kick in to assist with perhaps unwinding the whole thing.
All right, thank you very much, everyone. The assignment sales and deals are very, very complicated. So definitely, if you are in the middle of one or about to do one, please make sure that you do have a solicitor review clause on both sides, and speak with your manager directly with regards to the clauses, etc., and the complexities that are involved. Question for you, and it certainly, I believe, determines on how the wording is in an assignment agreement, but an original buyer, so the assignor, can either have his or her original deposit paid out immediately upon acceptance or final bill to approval of the assignee or the assignment, or it can happen on closing, right? It really depends on how the offer is worded.
Correct. Yeah, there's both options available.
Yeah.
In that, in the ORIA form specifically, there's the different options available. Yeah. And
everyone, keep in mind, we currently do not have an assignment listing agreement, which we desperately need, but definitely the agreements of certainly when you're formulating a purchase or an assignment deal, those forms are available.
I'm going to end on one thing, if I could. As lawyers, we also have these kinds of seminars by our insurers and law society, etc. So one of the things that was repeated 4 times the other day at one of the seminars I watched was document, document, document. And I say this all the time, so it bears repeating for realtors: document everything you do, because I have a case that I'm involved with right now, and there's a question on the part of the deal didn't close, we'll put it that way. And there's a question on the part of the the vendor rather, whether the realtor protected her interests. And so, of course, memories fade after the course of a year and a half, 2 years. And so it's really important that as a realtor, you document, just like for us, you document everything you do, all the advice you gave. So if you say to your client, maybe you should have your lawyer review this assignment agreement before you sign it. And if they say to you, oh, you know what, we're going to lose it, I'm sick and tired of all these offers we're putting in everywhere, just get the deal done. Make sure you got a record of having said that. Make sure you have a record of advising to get tax advice, legal advice. If it's conditions for financing, then so be it, or home inspection conditions, whatever it is, document, cover yourself, because people forget. I say it all the time, but I think it's important to repeat it every time, because in this hot market, we skip a lot of steps to get the deal done. And you just don't want it to come back and bite you later.
No, I agree 100%. Form 127 is a great form to use for this. Cover your assets, everyone. Make sure you have those conversations with your clients regarding potential ramifications. And again, always involve legal advice for sure. I think that's it.
Fantastic. Thanks again for the opportunity. On behalf of Vince and Joanne and Matt, thank you so much, Louise and Ivana, for the opportunity to speak again today. And we'll look out for you on a future presentation.
Thank you so much. We'll have you back again. I appreciate your time, all of you. Thank you. Have a great day, everyone.
You too.